Hello, everyone. I'm Dan Farber. I'm on the faculty here teaching a variety of things, but most of my work is in con law, administrative law, and environmental law these days. Along with John Gould, I'm the co-director of the Edley Center on Law and Democracy. So I want to say a little bit about the center, then a little bit about the panelists and what we're going to be talking about, and I'll turn it over to them. I'm actually one of the panelists too, but I'm hoping to play sort of a trailing role. So the center's named after Chris Edley, who was a transformative dean here. He came here, I don't know, a little less than 20 years ago, I think. And he really changed the place. I mean, for one thing, that whole courtyard where Zeb is nowadays and the library and stuff, that's all his. He also dramatically expanded the faculty, led the creation of new clinics and of the research centers that we have today. So really his fingerprints are all over the law school today. He was also an important administrative law scholar. He was very active in the public policy area, and he had served in the White House and other parts of the government. So it's especially appropriate that we've named the center after him. Democracy was an important focus of his work, and it's the focus of the center. I think many people today, maybe almost everybody, would agree that there have been serious abuses of presidential power and that there could be more. Of course, people would disagree, about 47% to 47% about which presidents had done what that we need to worry about. But I think everybody kind of shares a concern about the power of the presidency. And that's the topic of today's panel. So we have, in addition to me, two speakers. Professor Sharon Jacobs is a leading national scholar on administrative law and on energy law. And she is going to be talking about the tools that modern presidents can use to sort of kneecap, I'm probably putting it a little more bluntly than she would, but to kneecap administrative agencies whose work they don't like. And change policy through a variety of techniques that way. John Yoo will argue that the use of criminal prosecutions to block Trump from the ballot failed and in fact backfired. I guess from that maybe he'll have some observations about the role of criminal law in terms of the modern presidency. And then I'm going to talk about something a little bit related to Professor Jacobs, which is the sort of increasingly dominant role that presidents have played in shaping policy all the way across the executive branch, sort of how that came about and why at least in my view, it may have gone a bit too far. So we're actually going to start with John, even though I introduced people in another order, and then Sharon, and then me. Thank you. All yours.
Well, good afternoon. It's great to be here to honor Chris Edley. I was on the faculty and voted to, I think you were too, Dan, voted to appoint him dean. It was a happy vote. I agree with Dan. He was, to me, the most capable academic administrator I ever met in my life. I'm sorry that most of you probably never got a chance to meet him. We probably disagreed on every major issue of public policy, but it didn't get in the way between us. I completely agreed with his vision of the school. I was hired here when the faculty was 30 people. And Chris came in, and I think when he came, it probably was only 40 people. And he had the vision that law schools would themselves become little colleges, and they would have departments effectively, and that we would have huge programs with students from abroad. All of that, all the centers, our big LLM programs, our competitiveness with other schools, all because of Chris. He is my great regret that he did not become chancellor of the university. I'm still not sure why that didn't happen, and instead we appointed some joker from Columbia who lasted like a year and a half because he thought the university should pay for his workout regime when he was traveling. That would never have happened under Chris. He was just a remarkable leader. I also want to thank Dan and John Gould for putting this new center together. I think it's a great tribute to Chris. I'm not so sure, actually, whether Chris was pro-democracy or suspicious of democracy. He really was, he was very thoughtful about this, and I had many conversations with him. All I know is I am sure he would be so happy to have a center named after him that engaged in vigorous free speech debate. That's the most important thing. He was very happy to have people on the faculty like me who didn't agree with him about anything, as long as there was free and fair debate and open free speech. And I like to think that that will happen here. I have been extremely worried about the status of free speech on our campus and the campuses at other schools. I was at the attempt to hear from Simcha Rothman, the minister of the Knesset. I mean, this is an official of a foreign government, an official of the Israeli Knesset, and he was not able to give his speech. I thought that was my understanding is that this was really not the work of students. It was people from off campus who disrupted the event, but I thought that was terrible. And I know Chris would never have stood for it. I was really disappointed. That said, if you want to shout me down, I'll give you lots of opportunities now. So it's also, I should say, a pleasure to be on a panel with Sharon, whose work I think is really innovative. I hope that you will find it extremely boring, though, because she's not going to disagree with me, I hope. But we'll see. It'll be exciting. So my basic argument, and I've got a little essay I've written up about this, is that the effort to use criminal prosecution to drive Donald Trump out of the election was a failure. I think it was a failure in the short term in terms of this election campaign season. I worry that it's going to have broader, deeper harms to the presidency and to our system. That's just a prediction. We can't tell for sure. Maybe it's a one-off, but I don't think it will be. First thing is, I just want to take issues with the way the center is described. You know, the center studies democracy. We're not a democracy. We are a constitutional republic. As I'm sure you'll learn, those of you who have already taken con law, there are many important features of the Constitution which are not just ambivalent about democracy, but are explicitly anti-democratic. Right? Our system does not run according to a simple majoritarian democracy like the United Kingdom, for example, or Japan, for example. Look at the United States Senate. Look at the Electoral College. Look at judicial review and the role of the federal courts. Those are all system institutions that were designed to suppress or limit pure majoritarianism. And so if you want to say, as I think people do say, the reason why we had to cross this constitutional Rubicon and prosecute a president, former president for the first time, the reason we had to, for the first time, also prosecute the major opposition candidate for president was because Trump represents an existential threat to democracy. Right? I've heard Trump say that. I've heard Harris say that. I've heard many people. In fact, I've heard Republican primary opponents say that. Right? This is a common theme. But one thing I just take issue with is the Constitution is already an existential threat to democracy. It is explicitly designed to prevent full-blooded 50.1% of the vote wins and run things from happening in our country. Look at the Senate. Wyoming, I think Wyoming is now the smallest state by population, right? It has 2 senators, and we in California get 2 senators. If you look at the Senate and you look at the filibuster, I think this is still the case. Senators from the number of states that represent as little as around 14% of the population can prevent legislation from passing. That is not a democratic system. you have a Supreme Court, right, which can strike down federal legislation. That's not a democratic system. So first, I just take issue with the idea Trump is this existential threat to democracy when we already have a system that is not democracy, is not supposed to be a democracy. But suppose you thought he was this one-time threat to whatever, our constitutional system, to our political norms. Is it still worth it to get him out of the race by introducing, for the first time on your system, right? We can have arguments, I'm happy to have them about whether the constitutional text structure might be read to allow for the prosecution of former presidents, allow for the prosecution of the main opposition candidate. But it really is the first time we've ever done it in over 2 centuries. Is it worth it to stop Donald Trump from running for office? I don't think so. And I'm not in any way defending Trump as a person. He's not my candidate for president. I would vastly prefer that Nikki Haley or Ron DeSantis have been the nominee of the Republican Party. But suppose everything everyone says about him as being a bad figure is true. That's the question I pose to you. Should we still have introduced using criminal prosecution to try to drive someone out of the election? In the short term, I think it actually backfired. The unintended consequence, it seems to me, was that actually the prosecutions helped Donald Trump. I went back and looked at the polling data. So at the end of 2022, this is so hard to believe, at the end of 2022, in polling of Republican likely primary voters, DeSantis was the #1 choice, and he led Trump by 15 points. Then all the lawfare stuff starts happening in 2023, right? Multiple indictments. We have 4 now, 4 indictments of President Trump. Atlanta, New York, at the state level, a special counsel's appointed. He brings a prosecution first for classified document storage and then for January 6th. Trump, I think, and you listen to accounts of the people who ran against him, Trump and his trials come to dominate the Republican primary season. Maybe people in Berkeley weren't paying much attention to this, but I was. And what happened was every time Trump was prosecuted, every time something happened in the courtroom, all the media attention focused on him, and nobody knows what Nikki Haley's education plan was. I bet no one can tell you what Ron DeSantis' plans for the economy were. Because, and I think DeSantis has said this, all the political atmosphere was just sucked out of the room and focused only on Trump and his trials. And it had the effect where, before this happened, DeSantis was 15 points ahead. By the primary election season, Trump is 15 points ahead of all his rivals. So if you wanted to drive Trump out of the election, this was actually a terrible idea. I think it also has a harm to our system that go beyond that. And then I'm not going to go through all the cases, the different trials. I'm happy to. The thing that worries me in terms of the use of prosecution, I'm not saying presidents should never be prosecuted. I think if Trump actually, you could prove in court, you could bring indictment, prove in court that he was an insurrectionist, that he was seditious, I would be happy to say that is the kind of case where you should be able to try a former president. What disturbs me is that the head of the executive branch, Joe Biden, and the Democratic candidate for president, Kamala Harris, are saying that, right? They're saying Trump is an insurrectionist. President Biden has said it many times. They are also head of the executive branch. They have the duty and the responsibility to be in charge of federal prosecution. I was quite surprised when I read Jack Smith's indictment, and it wasn't for insurrection and sedition. I encourage you all to read it. It is a big letdown to say that a former president tried to overthrow the government when you're giving speeches. When it comes time for the Justice Department to file charges, they charge Trump with trying to defraud the United States government, the same criminal charges that are used against defense contractors and Medicaid and Medicare fraudsters. The Supreme Court has suggested several times that this crime can't even be used against politicians except in very narrow circumstances. The second charge is destroying evidence or trying to obstruct a congressional investigation, which the Supreme Court just held can't be used against most of the January 6 defendants. I don't think that charge is going to survive. And then the third charge, I don't think ever brought by the federal government before, charged Trump with depriving every American voter of being deprived of their voting rights by trying to change the electoral count outcome. I'm saying, even if all the facts are true, right? It's like a 12b6 motion. If all the facts are true, I don't think these charges actually fit the crime, and yet the Justice Department and the special counsel did not charge Trump with what they're saying he's guilty of. Insurrection is a federal crime. Sedition is a federal crime. They should charge him with it. And if they charge him with it and they bring the facts for it, then I would say, yes, you should be able to charge a former president with that. But to build this all up and charge him with fraud, right? Obstruction of a congressional investigation, that's why I think people think the Justice Department's playing games. I'm not saying they are, but this is a huge letdown compared to the political importance of the case. One last thing, and then I'll stop and turn it over to my colleagues. That's the only way, to me, that makes the Supreme Court's immunity decision make sense. Before the decision, I wrote a piece, very happy to go through the arguments, that I did not think presidents have immunity from criminal prosecution. If you look at the original understanding evidence, Alexander Hamilton repeatedly says presidents, once they leave office, can be prosecuted. I don't think there's really much historical support for the idea presidents have this immunity. So why does the Supreme Court grant this? I mean, I think most people are shocked, not just at the immunity, but the breadth of the immunity is really quite unbelievable. Why did they do that? I don't find the opinion itself very convincing. I can only read it as an effort to try to stop the use of criminal prosecution as a tool in federal election campaigns. That's the only reason it makes sense to me. So it doesn't make sense as a matter of doctrine, text, and structure, which are our usual guideposts to constitutional interpretation. I think the Supreme Court believes that it's playing some larger role, small p political role or constitutional political role by trying to stop the use of prosecution as a tool in electoral politics. Otherwise, I actually quite agree with most of the people who criticize the decision in Trump versus U.S. So what's going to happen? And I'll throw this open to you. What is going to happen if we allow this to continue? It's almost certain to me that we will have reciprocal retaliation. There's going to be some prosecutor in Texas who's going to prosecute the Bidens now, or is going to prosecute the Harrises if this goes further. You're going to see special counsels appointed to investigate people from both sides. It's not just going to be, I think, one-off against Trump. And then the larger problem is, what effect is this going to have on the presidency? I don't talk about that much. That is the root of the Supreme Court's concerns. You have the desire by the founders when they created the presidency that you have one branch of the government that can act with energy, right? You read Federal 6970, someone can act with speed and deliberation, sometimes secrecy, to execute the laws and to protect the nation's security. Do you think that the presidency is going to continue to enjoy those virtues if presidents are always worried about their after office, right, after the fact legal liability? I think it's going to have a damaging effect on whoever's president. It'll have a damaging effect if Kamala Harris wins. I think we'll have presidents who become risk averse. And that is quite counter to the idea that the founders had when they created the office. So thank you very much. I look forward to questions and discussion. Thank you. It's okay to clap. You don't have to.
So I think it was the Monty Python boys who said something like, and now for something completely different, which is what I'm going to be offering you. And I think you'll be able to tell as you listen to the three of us, this idea of presidential power is vast and encompasses a lot of different spheres of activity, a lot of important legal questions. So I'm going to be talking not about presidential liability, or at least not directly, but I'm going to be talking a little bit about presidential power over administrative agencies. I only only recognize one or two faces from this room, which makes me think that you all either didn't take administrative law or haven't taken it yet or haven't taken it with me. The latter is absolutely fine. The former, I think, is problematic, and I would encourage all of you to take a course in administrative law in your time at the law school. For those of you that are students, it is essential these days to understand the workings of administrative agencies if you want to understand policy and if you want to understand how government is functioning, whether we call that democratic governance or the functioning of a republic. You have to understand how agencies work and also the relationship of the president to administrative agencies. So I'm going to be talking specifically about presidential power to limit agency effectiveness. And that might sound odd because when it comes to presidents and the bureaucracy, the story that we've been hearing for years and years is that presidents have increasingly amassed control over agencies. They've found ways to effectuate their policy programs through administrative agencies. Justice Elena Kagan, when she was a professor, wrote a famous article about this called Presidential Administration, in which she talked about the growth in presidential control over agencies over time, specifically during the Clinton administration, which she was a part of. And she detailed the ways in which President Clinton made use of agencies to accomplish domestic policy goals through helping to set the agendas of agencies and focus them on particular problems, through the review of agency decisions prior to their issuance, through claiming credit for agency action. You know, this is the first time that we start hearing kind of across the board, we have done this, right, in the executive branch, as opposed to the Federal Food and Drug Administration did this, right? So it's not that President Clinton started this. This is a longer-term trend, but she was writing about the ways in which President Clinton in some ways perfected this art. So I'm not talking about, I don't want to talk about that today. I want to talk about a different way that presidents can impact what agencies do. Not by using their authorities to serve policy aims, but by weakening the infrastructure of the agencies themselves to either undermine their ability to function in general or in particular policy domains. So presidents with a deregulatory philosophy have a variety of tools that they can use to dismantle agencies, potentially even, although we haven't seen this taken as far as I think it could be, to incapacitate agencies to prevent them from accomplishing statutory goals, directives. And Jody Freeman, who's a professor at Harvard Law School, and I wrote about this in an article in 2021. We call this phenomenon structural deregulation. We mean to contrast it with substantive deregulation, which I think of as, say, statutes that roll back delegations to administrative agencies. So if you think about some of the big environmental statutes like the Clean Water Act that give the EPA a variety of authorities to set standards for water quality and to monitor those standards and to enforce the act against violations of those standards, Congress could write another statute tomorrow that takes that authority away from the EPA. That's substantive deregulation. We don't take a position on that in this piece. People have different theories of government and different theories about how much work the federal government in particular should be doing when it comes to regulatory programs. Our goal in the article was not to take a side, although of course we have our own views, but instead to say that no matter how we feel about substantive deregulation, we should be really worried about this more subtle, sort of difficult to discern version that we call structural deregulation. And there are a variety of techniques that we describe in the article that we offer as examples of this. In fact, we title one of our subsections 50 Ways to Kill an Agency. But the advantages to each of these approaches, I think, are the fact that they are a little more obscure. They don't tend to be in the spotlight. They don't tend to make the front pages of the news or whatever the equivalent is if you watch cable TV, which I try not to. And they're less formal than, say, repealing a statute or going through the trouble to repeal a regulation, where presidents, you know, if they want to ask agencies to take that on, the agency has to go through a more cumbersome process under a statute called the Administrative Procedure Act. So here are some of the techniques that we identified. The first has to do with staffing of agencies. So agencies can't do their work without people. right? And the federal government employs a large number of people to do the work of agencies. So one way in which presidents can affect staffing is simply by declining to fill open positions. When people retire, right, there's sort of natural attrition in agencies, and presidents can say, we're going to slow walk hiring or we're going to freeze hiring. So there was a hiring freeze during the Reagan administration. There was another hiring freeze during the Trump administration. Democratic administrations have seen various sort of short-term freezes and moratoria as well. I don't mean to imply that this is any of this is purely sort of a Republican versus Democrat phenomenon, although, of course, there is a difference in terms of how the two parties see the work of administrative agencies. And when positions become vacant, either they can just be left vacant, which means nobody's doing that work, or sometimes agencies can hire temps or contractors, which might fill the gap in some ways, but can be less effective. Another technique that we've seen is the inducement of retirement. So getting people who have been at the agency for a long time to retire, you can do buyouts. Another interesting technique we've seen is relocation as an inducement to retirement. So the USDA agencies in the last administration were relocated, a couple of agencies within the USDA, from Washington, D.C. to Kansas City, Missouri. And the agency provided some justification for those moves, but 2/3 of the employees that were assigned to be relocated quit. We saw a similar pattern when the Bureau of Land Management was relocated from D.C. to Grand Junction, Colorado. I used to live in Colorado. It is beautiful. Grand Junction is also beautiful. I hope you will all have a chance to visit. But almost 90% of the employees that were reassigned quit. So this is a known phenomenon, and our argument is that these tools, and I'll get to this in a minute, can be used for benign purposes, but can also be used in a sort of coordinated way. Failing to nominate permanent leadership of agencies, so leaving vacancies open at the top of agencies. Presidents are busy, we get it, right? There are a lot of things that we ask them to do, but agencies without permanent leadership may be less effective than agencies that are run by acting administrators, and commissions, in particular independent commissions that don't have a quorum to act. So when the Federal Energy Regulatory Commission is missing 3 of its commissioners, right? Or it's, for some agencies the problem was worse. There are certain actions they can't take without a quorum. Structural changes to staffing mechanisms. Your eyes may be glazing over at this point, but I promise you that these tools are actually important, right? So staffing mechanisms, understanding how the Office of Personnel Management works, that was new for me when I was working on this paper, but there are offices within government that are solely responsible for staffing and maintaining the staffing of the federal government, and the ways in which they do that matter. Another set of tools we looked at are agency resources beyond staffing. So budget, right? The president has lots of tools that they can use to affect the agency's budget. Congress sets the budget, right, through appropriations. But the federal government, the president and the Office of Management Budget can set conditions on agency spending, can reprogram funds within limits, and also, this is one of the ones that I love, can create busy work for agencies that take up staff time. And one of my favorite examples of this is the renaming of the Consumer Financial Protection Bureau. So when Mick Mulvaney was in charge of the Consumer Financial Protection Bureau, created this fairly robust committee within the agency to think about switching a few of the letters in the agency's acronym. And this took up working time. It took those employees away from other things. And the justification was, in some places the statute refers to it with these 2 letters reversed. But the statute also referred to it the other way. So that's just one example of busy work. Again, you don't have to buy any of these specific examples as problematic to agree with me that there are tools available that can be deployed in a systematic way to tie up agencies. Agency expertise, right? Not just the failure to fill certain types of positions within agencies or across the board, but certain categories of employee within agencies like scientists or economists or the people that do the work of defending, say, agency rules and make sure that those rules are tested and can survive judicial challenge. If we thin out those ranks, agencies will be less effective. And then finally, reputation, which is kind of a more amorphous category. But there's been some work in political science to talk about the idea that agencies have a reputation as an organization. And that reputation enables them to do certain kinds of work. It enables them to have certain types of interactions with Congress. If Congress respects an agency, they say it's more likely that they'll get funding for all of their programs in any given appropriation cycle, for example. It can impact how successful agencies at recruiting staff. And we have had examples of presidents undermining their own agencies, right? Speaking in public about how incompetent or confused these agencies are. It's just very different from the Kagan understanding of presidents as working with the agencies to accomplish statutory goals. Just a very different approach. So we think of the potential to use these things together as creating a scenario for death by 1,000 cuts for these agencies. We think this is really problematic, potentially problematic, and we think that people should agree that this kind of structural deregulation is problematic, again, sort of regardless of the position you take on any given policy issue, or even the position you take on the right size of the federal bureaucracy. You think it should be smaller, right? Again, Congress is the one that should rewrite statutes in a way that reduces the size of administration. But the really hard thing about this is that it's hard both to distinguish structural deregulation from what you might call good governance, and there aren't a lot of legal tools to get at the problems that we're describing once you agree, if you agree, that they're problems. So, we talk a little bit about ways you might try to distinguish in any given case, whether you want to label something structural deregulation or kind of efficiency within government. So you might be able to find statements, and we do, and cite examples in the paper, that elucidate motive, right, within the executive branch that seem to suggest that, oh yeah, we did actually move the BLM to Grand Junction because we wanted the whole office to quit, right? Sometimes you get statements, kind of smoking gun statements that tell you what the goal was. There may be kind of a poor fit between the action and the justification that's given. That's what courts use in a variety of circumstances to evaluate actions. And there could be conflict and significant disagreement even within the executive branch about whether to do these things or not. Those can all be contextual clues about whether you're dealing with structural deregulation or not. I won't go into kind of the reasons that this is hard to get at legally, except to say that we don't find any sort of constitutional arguments that we think would be easy to bring in court. We don't think administrative law itself really wrestles with this question. We don't think there are a lot of statutes that defend against the kind of actions that we're talking about, which really leaves us with Congress as sort of the best defender against structural deregulation. And we think there are a lot of things that Congress could do to potentially protect agencies. One thing Congress can do is they could be much more specific in statutes about what an agency should look like, what its level of staffing should be, where it should be located. There are obvious downsides to doing this, and I want to acknowledge that, right? Congress delegates frequently and creates agencies with a fair amount of flexibility and play in the statutes so that those statutes and those agencies can evolve over time to deal with new problems, for example, and Congress doesn't have to keep going back and rewriting these statutes over and over again, but Congress could be more specific if it wanted to. And then, actions like removing particular agency officials and not filling those posts might be legally problematic. Congress could do things like capping the number of agency officials that can be reclassified, and something I'm happy to talk about a little bit more in the Q&A, but we have seen various presidents wanting to reclassify agencies from a civil service category where they have a lot of job protections to kind of political appointees where they can be removed at will by the president. If you get large numbers of employees that are reclassified in this way and then removed at the same time, that could create problems for agencies, right? So there are things that Congress can do here. There's also more oversight that we think needs to happen. So offices like inspector generals within agencies, but also kind of overarching organizations like the General Accountability Office, the Administrative Conference of the United States. Like, these are entities that could keep an eye on what's happening in agencies, so that we could tell if the staff level at a particular agency is falling, right? Journalists are starting to be a little bit more interested in this, but have to make sure that Congress is aware of what agencies' potential resource problems might be in order to do anything about it. I don't want to imply that any of these tools became newly available in the Trump administration, but I will say that I think President Trump and his administration used them to greater effect than perhaps some of his predecessors, in a similar way to the way President Clinton, right, managed to use agencies to greater effect than his predecessors in effectuating domestic policy. But again, this is not about one administration, right? There have been reports that staffing levels have been dropping, or before President Biden put in place some measures to restaff agencies, have been dropping for about a decade, right? Under President Trump and under President Obama as well. So I think I will stop there. I just wanted to give you a sense of what I think some of these tools are. Maybe we'll have a chance to talk about them a little bit more and their potential use in either a Harris or a Trump administration. But I will turn things over to Dan.
So thanks. I think my remarks will actually sort of fit most directly with what Professor Jacobs had to say. I want to say a few things quickly about Professor Yu's remarks, and I want to begin with an apology because I was in a hurry to get to the panel and I kind of skipped over his introduction. So let me just say, as a law professor, he has been sort of is probably best known for his work about presidential power and national security. And he also has played an important role in the Justice Department on some of those issues. I don't want to directly address the substance of his remarks, at least not at this point, but I wanted to just say something quickly about how they fit in with some of the other panels and remarks on those panels. So in our last session, Professor Oren Kerr talked about the Trump immunity case. And I think in some ways he had a similar perspective, but maybe a little bit different. I don't know, you might agree with him, that the key to the decision was that the court was viewing Trump, or what he did in 2016, as a one-off, and that they were concerned about the long-term effects of allowing criminal prosecutions in the way you said. So we had a discussion of that last time. The video has just been posted, so I recommend that if you haven't seen it. I also was struck by John's remarks about the undemocratic nature of the Constitution, because although actually agreeing with Deans has not been your sort of standard operating procedure on policy. Not necessarily on law school stuff. But here's a case in which I think you're exactly on the same page as Dean Chemerinsky.
Wait a second.
Yeah.
But I like that it's undemocratic.
Yeah, that's exactly the difference, right? The dean thinks also that the Constitution is inherently undemocratic, but he thinks it's a reason why we need to rethink the Constitution. And he's just published a book about that. He will be on our next panel in 2 weeks, talking about the role of the courts in democracy. Let me pick up with part of Sharon's remarks. She mentioned Justice Kagan, then Professor Kagan's famous article about presidential administration, and that's really going to be the topic of my talk. I agree that I think Justice Kagan was thinking of presidential administration in terms of some kind of cooperative attitude, coordination between the White House and agencies in which the White House would basically provide general direction and would coordinate between agencies, because quite frequently there are a lot of different agencies that have jurisdiction over some piece of a problem or overlapping jurisdiction, and someone has to sort of smooth that out. And that she thought this would provide more coherence to government, give the public a clearer sense of, why presidential policies could matter, and, in general would make the government operate more effectively. I guess my concern, and I would say that there's sort of a more extreme form of presidential administration called the unitary executive theory, under which, basically the president sets all policy, at least in principle, and the role of everyone else in the executive branch is to carry out the president's policies. And I don't think that, in principle, the fact that constitutionally the president could micromanage every single policy thing necessarily means that supporters of the unitary executive theory think the president ought to, or that the president, shouldn't listen to subordinates. I'm pretty sure that's not the view. But what I worry about is that we've kind of switched from an era, and I've read some recent history about this, in which administrative agencies thought their job was to carry out their statutory missions, into a world in which the basic picture is administrative agencies should carry out presidential policies except where statutes make it impossible, right? So that the main policy official, except for the inconvenient existence of statutes that might get in the way or might fail to authorize something, the policy is really driven from the top. I should say, I think the Supreme Court has a kind of ambivalent view about this. When they're writing about the president's power to hire and fire subordinates, they're very big on the idea that president's policy, must provide the guiding direction of the executive branch. On the other hand, that was kind of one of the things they hated about Chevron, right? That every time you changed a new president, regulations would just flip. First you have Obama wanting to take action on climate change. He does some regulations. Trump comes in. He reverses all of those. Biden comes in, reversal again. And they didn't like that for what I think are, at least partly good reasons. I think to some extent they dodged acknowledging that that's what Chevron was about, with a sort of fiction that agencies like EPA are doing these big regulations on their own and are deciding whether to do something about climate change or whether to adopt a particular approach to regulation. Whereas, in fact, I think that they're pretty tightly supervised by the White House on these things. I think the sort of turning point may have been in the early Reagan administration with Reagan's executive order on cost-benefit analysis. And the thrust of the executive order was that, except where precluded by a statute, courts ought to make all their regulatory decisions based on cost-benefit analysis. Now, there are very few statutes, there are a few, but very few statutes that actually call for the use of that standard. But there are also not a lot of statutes that explicitly reject the use of cost-benefit analysis. And so essentially statutes were being viewed as only potential barriers to the preferred regulatory approach of the White House. And the White House has exercised increasingly close control over agencies, not just on matters of major policy and regulations, but we don't get to see much of this, but when we do, basically the White House is editing the agency regulations in great detail, right? Stuff comes back from the White House covered with red ink. And so, again, I think the increasing amount of power is concentrated on the White House. And I think people in the White House have no particular reason to be worried about what policies Congress was trying to implement under a statute. Naturally, their job is to try to get the president's policy implemented, except, of course, they don't want to violate the law, if only because the court might reverse it. So I think there are some benefits to this approach along the lines that Kagan talked about in terms of greater coordination between agencies, greater coherence to government policy, et cetera. But I think we've also been seeing that there's some real downsides. One of those, I think, is to undermine the role of Congress in setting policy to the extent that Congress has set out a direction for an agency, but without strictly mandating the exact parameters of that. The agency is sort of increasingly encouraged to ignore statutory policies. And I think it regardless of overruling Chevron, will still encourage great gyrations between administrations because there are non-statutory grounds for reversing regulations, right? Even if the interpretation of the Clean Air Act doesn't change between administrations, there is a lot of room to maneuver based on, findings about expert evidence and so on and so forth. And so I think we're still going to see pretty large changes. I think it may, besides increasing instability, can also sort of further the polarization of politics if everything in a whole government does depends only on one person. And you either agree with that person or you don't. That really raises the stakes in presidential elections, which are high to begin with, obviously, but it's even more when you think that, nothing will continue as it has been necessarily if we change who the president is. And I think it concentrates power in one individual to an extent we ought to be uncomfortable with in a country that's prized the rule of law. I'm actually, I see the argument that presidents will be deterred by the fear of criminal prosecution. On the other hand, I would like them to occasionally worry that they might be violating criminal laws. And I just don't really, I'm not sure that's otherwise really on their radar screen, right? Maybe that doesn't show the amount of confidence that I really should have in the character of the people in the White House. But I'm just not sure that they take legal constraints quite seriously enough. And certainly on a day-to-day basis, they have a lot of opportunities for operating otherwise. So I don't call for abolishing presidential administration, but I do think we ought to worry about ensuring that the entire executive branch isn't just sort of a mirror of one individual's views, that Congress is taken seriously as a sort of source of policy, not just as a source of constraint on policy, and that we be able to take advantage of expertise rather than having a government of sort of yes men who were afraid to get out of line for fear of being fired. Okay, so I think I've talked a little longer than I planned to. Let me begin just by giving everybody an opportunity to respond to other speakers, and then we'll open it up to the audience. Thank you. You can applaud.
I have one point that's not a response. It's something I didn't get to, and then I have one question or point for Sharon and Dan. So the thing I didn't get to was this whole question. I'm trying to figure out how to connect what these have been about. And so one question is, And this was something that really was central to the founders thinking about the presidency, is how do you give the office the kind of virtues I was talking about without allowing someone to become a tyrant. And so if you don't have criminal prosecution, I don't want to be read to be saying there are no restraints. Obviously, you'd want the president to obey the law, the written laws in the Constitution, but there's also impeachment, which was reinvigorated under the Trump presidency. You have, and I'm sure we're going to have many more impeachments in this century than we ever did in the last 2 centuries. I think actually elections, I think that if you had not prosecuted Trump, that both the primary and the general election will be the American people's opportunity to render a verdict on Trump's fitness for office and what he's done in the past. And then I'd say for the political process, so Sharon gave us very interesting list of all the ways that presidents can contest for control of the agencies. And Congress has this, its own countervailing set of tools. I did work in Congress, so I thought anytime you want the executive branch to do anything, you just cut off funding to the agency and it'll happen like that. The Congress has a lot of tools that it can use to constrain a president and agencies, oversight hearings, legislation, the funding power, right? Just the general political process. I think sometimes we've lost our faith in it as a constraint on the presidency. So one question for both of you in terms of this phenomenon of the president being able to sort of control the agencies or bend them to his or her agenda rather than what might ever be their statutory agenda. I actually thought the most powerful tool that has arisen is symbolized by the DACA and DAPA programs in immigration, where put aside staffing, relocation, what if a president just says, this statute orders the agency to do this, and I'm only going to do 10% of that or 5% of that. I'm not going to do 0%, but I'm going to do really, really little. There was no effective way to, right, because the courts have said prosecutorial discretion is unreviewable in court. I don't think Congresses are going to impeach presidents for, not fully unenforcing the law, but coming close to it. I thought that was actually the most powerful tool I've seen in a long time for presidents to actually shape the agenda of what agencies do. And so the question I have is, since the Supreme Court, has so far chosen not to address DAPA and DACA, they kicked out a case actually about it. What would happen if President Trump or President Harris came into office and extended the theory of non-enforcement to lots of other areas of the law? Suppose President Trump says, Congress won't vote the tax cuts I want. I'm going to set a 20% flat tax. Everybody pay up to 20%. I'm not going to enforce anything above 20%, but I will enforce up to 20%. Is that really constitutionally different than the DACA and DAPA programs? Would there be any way other than just political methods I've laid out to restrain him? I don't think so.
Yeah, thanks, John. So, I want to talk about maybe non-enforcement first and then come back to this larger point about Congress and its role that you raised that I think is really important and does cut across what we all were talking about. So, taken to an extreme and exercised in a particular way, I do think non-enforcement can be either a version of what I think of as structural deregulation or sort of a more substantive deregulation, but one that doesn't follow the established legal processes that we would like to see to have confidence that the decisions being taken by the executive branch are actually consistent with the statute. So, you're right that the law, it is challenging to challenge non-enforcement of statutes. It's not impossible, right? So, a case called Heckler versus Cheney establishes a presumption of non-reviewability when the executive takes decisions about when to enforce and when not to enforce. There's also, so that's just a presumption, and you can show that there is something illegal, right, about the non-enforcement. And the courts have also treated kind of decisions not to enforce across the board differently from decisions to reduce enforcement power in a particular area to like 5%, right, or 6% or something like that. And something I think that you've written about this really resonated with me, which is that the take care clause in Article 2 of the Constitution is a duty imposed on the president to make sure that the laws are faithfully executed. And so that in itself, I think, I agree, is not a power bestowed on the president. It's a responsibility given to the president to make sure statutes are implemented. So a blanket statement that the president's simply not going to enforce a statute or not going to enforce a program at all, I think is problematic. So maybe we agree there, and I'll be curious to hear what Dan thinks. Now, that doesn't speak specifically to the details of the DACA or DAPA program necessarily, which is, I think, a lot of our disagreements may come in sort of the weeds of individual policies and individual policy choices and whether this was a sort of plenary non-enforcement decision. But certainly the example that you just gave of like, I won't enforce tax collection over 20% of someone's income, like that strikes me as pretty stark and problematic rewriting of the laws. I wanted to come back to, the role of Congress here, because I think Congress has been absent in a lot of ways. And I think that is leading to a lot of the behaviors and challenges and questions that a lot of us are discussing and raising today. Congress hasn't passed a major environmental statute really since the Clean Air Act amendments, right, of 1990. I mean, they've been a little bit more active in the space that I know best, which is energy law. But they haven't rewritten kind of the major statutes in that area either, the major regulatory statutes, since the 1930s, right? There have been some updates to them. And so, a place where we might have a lot of common ground, I think, is that a lot of us believe that the ideal way to make law in this country is for Congress to do it. In fact, that's the only way the Constitution envisions, right? They assign the legislative powers to the legislative branch of government. And it's Congress's abdication of that responsibility that has produced a lot of the action that we see in the executive branch. It's made possible a lot of the tools that I was talking about that I refer to as structural deregulation. A more active Congress could deal with a lot of these questions.
So I think the sort of under-enforcement issue is really interesting. And I do think, I think it's more common than people really think. DACA is sort of a headline example because it was very controversial. But for example, when Trump was in office, enforcement actions by EPA went down by like 80% or some number like that. And that's, the kind of policy shift that we do see on a more frequent basis, not these big dramatic programs. Probably the clearest example, I think, of I think even clearer than DACA, is marijuana, right? Where a succession of administrations have all decided that they're not going to pursue federal criminal cases for possession of marijuana in state, or sale even, in states that have legalized it. Even though federal law is 100% still in effect in those states, right? So this is essentially a deregulation through a combination of state decisions and just executive non-enforcement. It was interesting, the Trump administration made noises early on about retracting that policy. They sort of retracted it, but there were no changes in actual prosecutions as a result. And it now seems to be really quite entrenched. So, I think it's not just something like DACA that raises this. And it is an area where it's very difficult for courts to intervene in upholding in dismissing an action against the Biden administration for changes in immigration priorities. The court did recognize some exceptional cases where they thought judicial review might be possible, but they're pretty narrow exceptions. Okay, let me open it up to the audience. Since we're recording it, I'll pass around the mic because we discovered, like after the first session, that nobody could hear the audience questions on the video. So, the floor is open. Okay, let me start over here.
Thank you. This is a question for Professor Yu. And you discussed Jack Smith's criminal indictments of Donald Trump as criminal indictments that were an attempt to drive him out of the political process. And if that is true, why did Jack Smith decide to go with the conspiracy to defraud rights as opposed to the insurrection, which plausibly, according to the Constitution, could have actually prevented him from reassuming the presidency? It seems to me like the conspiracy to deprive rights is actually a more accurate depiction of what he attempted to do throughout the post-election process, as well as an easier and more well-developed charge, as opposed to an insurrection charge, which was less tested and more likely to run into constitutional legal issues.
I've been puzzling about that myself, about why is the indictment, I think, so anticlimactic compared to the political rhetoric. In fact, I think the charge that you mentioned, this is the third charge, which is the deprivation of voting rights. That actually is completely untested, the way it's set out in the indictment. To say that a candidate has actually deprived every voter in the country of their voting rights by trying to interfere with the electoral count, that's never been charged before either. And it's a theory of conspiracy. It's extremely broad because I guess theoretically then, does that mean the members of Congress who voted, I think I think factually they had no basis to vote this way, but you had significant numbers of members of Congress vote to throw out electoral votes from certain states. Are they also guilty of conspiracy to deprive people of their voting rights? That's the theory of the charge would say so, but I can't believe that you should be able to charge members of Congress with a crime for voting this way in a procedure set out by the 12th Amendment. They were taking part in the 12th Amendment vote counting process. So this is why I find disappointing. That's why I'm arguing that the use of criminal prosecution really doesn't fit the electoral purpose, because even the Justice Department, armed with all the resources it had, would not charge Trump with what he should have been charged with if you believe the facts as they've been set out. Like, why not charge him with insurrection and sedition if you think, as Jack Smith appears to in this latest filing, that Trump was the center of a conspiracy to inspire this attack on the Capitol and to stop the electoral votes from being counted?
Yeah, I also have a question for Professor Yu. Over here.
Oh, sorry.
So your argument is premised around the argument that Trump was indicted because he was a candidate, and this was to sandbag him as a candidate. I think you and I can agree that indicting candidates to sandbag them is wrong. The question I have is that a number of liberal commentators would counter and say that Trump knew he was going to get indicted and declared his candidacy early. He declared 3 months earlier than most Democrats in 2020 did, and 6 months earlier than DeSantis did. I'm wondering if that argument, if assuming it's true, would change your analysis. And then I have a second question as well, if you'll indulge.
So actually, I'm glad you mentioned this, because this was a point I forgot to make. Is this is actually something where we can learn from other countries, right? Even though we've never done this for 200 years, there are several other democracies that do use criminal prosecution in this way. I am originally from South Korea. I think every president in South Korea's recent history has been either prosecuted or thrown in jail. This is like a regular tactic in the change of political power in Korea, as they prosecute their predecessors. Brazil, right? We have the current president was in jail. He's now having the past president prosecuted. And then Italy has, and I think Italy is the one where your point might be borne out, because what I'm thinking about is, what are the incentives if we do allow this in the future? So if we do allow criminal prosecution against candidates or former presidents, what is the incentive after the Supreme Court has issued this broad immunity decision? It's to become president. That's the only way to defeat this kind of prosecution. And it's also going to encourage people you don't want to be in office to stay in office as long as they possibly can. right? So I think this, when you look comparatively at what's happened in other countries, that's what is going on, I think. And that's not a feature we should want in our system.
My second question, it might go a little bit broader than the presidency, but we've seen across the board in the U.S. A number of politically connected defendants claim that their prosecutions or investigations are politically motivated. Like Andrew Cuomo, during his sexual harassment scandal, claimed that the investigation was motivated by the AG wanting to primary him. You know, a number of Trump co-defendants argue that they're being prosecuted because of their political affiliations.
One's coming this afternoon to speak at 3:50.
I'm just wondering, like, what sort of guardrails you think are necessary to kind of separate the wheat from the chaff for, like, politically motivated prosecution claims?
I'm very curious to hear what Sharon and Dan think about this too, because I do think that small p politics is part of the prosecutorial function itself. That's why, in part, it's vested in the presidency, unlike in, you seem interested in comparative. In other countries, the function of prosecution is sometimes vested in the judiciary because they don't trust their executives with this vast power. If you look at the Federalist Papers and their discussion of what Sharon was talking about, why is the president given the authority to carry out the laws? It is because the president has energy and acts instantly. But they also thought that the president was more to be trusted to exercise the discretion of who to choose to be prosecuted with some degree of mercy and good sense, what we would call politics or policy with a small p, not partisan politics, but to have a political sense. And the great example of this is an insurrection. It's the Whiskey Rebellion, where George Washington leads the army to put down a refusal to pay taxes on whiskey, and then he decides not to prosecute any of the people because he wanted to be merciful. And so I think it's always going to be part of prosecution then that there is some kind of policy or some sort of policy or even political discretion involved. For those of you who never read, I don't think we even really assign this or read this much in law school, but there's a great speech given by Robert Jackson, who was FDR's Attorney General, and it's actually required reading when you work at the Justice Department. It's just a speech called The Federal Prosecutor. And he says, because the executive is vested with so much authority to destroy people's reputations before they even bring charges, and then you don't even need to bring charges to destroy someone's reputation, you have to exercise this with no partisan bias. I worry that I think 50% of the country thinks the other 50%, the other party will be doing that, no matter who wins the election, because I do think that these prosecutions of Trump and Trump's response, both of them together, have created this dynamic now where people don't believe in an impartial administration of justice. I think it's been one of the great losses of this electoral season, as that principle has been undermined. I think on the part of both parties are responsible. I think both people in both parties also believe it.
Maybe I'll just add, in a slightly different context where we're not dealing with criminal prosecution, but with Congress, which is a avowedly political branch, their ability to investigate the president. The Supreme Court held in a recent case that we need to recognize that the president is different, right? So the court found that when Congress was requesting documents from the president and his associates, the test for whether that request was too broad should be slightly different when the president is involved than when other officials are involved, right? So showing that it's possible to craft tests that take into account the role of the president while not, in that case, right, disallowing the collection of documents, but just sort of placing more guardrails around their collection.
Yeah, I guess just one quick remark on that. I think that it is a growing problem, and it's hard to know quite how to solve it. I think the idea that the president as being sort of in charge of and responsible for everything happening in the executive branch makes it worse, right? If you think that Biden is the one basically deciding whether to prosecute Trump, that feels different than if it's a prosecutor attempting, whose politics might be even different, attempting to carry out this traditional prosecutorial role. And I think this is sort of an example of how it hasn't helped, at least, that we have sort of raised up the idea of the president as being the puppet master throughout the executive branch. That being said, we do have safeguards for independent counsel, and clearly they're not persuading people that these are independent professional judgments, so I'm not quite sure how to fix it. I think we're out of time. I just wanted to add that we did have a discussion of Congress, and it's both internal dysfunctional issues, but also the problems with relying on Congress in a check in a hyper-polarized era in our earlier panel discussions. So it's certainly a really important issue. I think we can all agree on that. Thank you, everybody, for coming here today. It's been a great discussion, and I'm pretty confident that our next session, which will have Dean Chemerinsky and Justice Goodwin Liu from the California Supreme Court, about the role of the judiciary in a democracy, or a constitutional republic, if you will. I think that will be an equally stimulating session. Thank you.